There we go. Hello, can you guys hear me? Pablo, can you hear me?
Yep.
There you are. What's up, man?
What up?
Hey, what up, Tiffany?
Hey, how's it going?
Doing good, doing good. Good to see you. Hey, Pablo, are those real books behind you, or is that just like
I read them all twice. No, man, I just got this sweet green screen, bro. You see?
Oh, okay.
You didn't see that?
Oh, no, I
Yeah.
didn't see it.
Those are my other books are.
Oh, okay.
Yeah.
Okay.
So I got this green screen so that my background is super crisp, you know? And
Oh.
yeah, because if you don't have it, then it's all over the place.
Exactly. I feel you. Okay, everyone's joining, so we'll just give it a few minutes for everyone to join. Hey, what's up, Alex? Good to see you here. All right, we got April on board. So we'll just give it a few minutes. There goes Sanam as well. Cool. And then also, Pablo, my title company, they're going to be on too, so they could talk about some of these different, potential ways to hold title, and which would be cool. Hold on, somebody's asking me right now how to log in. Give me a second here. So we could kind of just talk about the entire, we'll give it a minute, but so what we want to talk about is just kind of, the big issue. There's a big issue. I don't know if you do any litigation with probates. It's kind of rare, I think, maybe, but I don't know if that's a big part of your business. We're not trying to take away a big part of your business. We're just trying to set people up for success down the road, right? Because I think that's a huge issue with a lot of people. They think once they buy a home, that's it. It's like, okay, I'm good, I'm finished. And a lot of my clients, and I would say majority of the population, is holding title in a way where it's not beneficial to them. So hopefully we could dig deeper into that. And let's see if our title people are on. Not sure. Jeremy, you on as well or no? All right. I don't see him on here yet, but let me pull up one thing on my screen, then we'll go ahead and start this. Hold on a second here. Okay, so, all right, here we go. Okay, so everyone who's on, I see Jeremy on there now. Thanks for joining. What we wanted to talk about in this workshop today is different ways to hold title to your real estate. And as I mentioned earlier, for those of you that were on, the way that we hold title, from what I've seen in my 18 years of selling real estate, it really affects your family's future specifically. And there's probably all kinds of ways that Pablo has seen it affect, different people, from people who inherit real estate all the way to lawsuits, whenever somebody falls and breaks something. So that's the thing that we're going to focus on. Everyone who's on here, is either in real estate or potentially owns real estate. And you really have to understand exactly that, once you own real estate, it's a great accomplishment. And I think a lot of people just take their foot off the gas, but they don't say, hey, well, am I protected? What's the best way to hold title to a property? What's the ins and outs? So that's what we're going to tackle today. So we have a couple people on right now. So we have Pablo Palomino. He's an estate planning attorney. So he looks over, your personal situation and your goals, and he basically, your assets, and then he recommends, hey, this is how we should plan your estate. That way it's the most benefit to you and your family down the road. And he'll go into details on how that works, and I guess his perspective as to whenever he's consulting with clients. And then we also have Jeremy Lipsey. He works for the title company, Lawyers Title, and they're the ones that actually insure real estate as far as the title goes whenever somebody buys real estate. So before I give the floor to Pablo to start, there's different ways to hold title to real estate. We have community property with right to survivorship, joint tenancy, tenancy in common, partnership, trust, LLC, corporation, different entities. So there's a lot of ways to hold it. So Pablo, if you could introduce yourself. I know I gave you a crappy introduction. You deserve a lot better than that, but go ahead and introduce yourself and talk a little bit about what you do in your practice.
Thank you, Voltaire. I first of all, I appreciate the opportunity to contribute to this effort. Brilliant of you. I pray and hope that everyone out there is being safe and engage in best practices to keep yours and your family safe. So I'm an attorney. I've been practicing law now 18 years this year, and my exclusive focus in that time frame has been in the areas of estates. So what I do for a living is I set up estates, or on the back end, I administer estates, or when people do not have proper planning in place, we handle probates, okay? With that said, I would add to Voltaire that next to ownership of real estate, how you hold title is just as important as owning title in the first place. I think oftentimes we get through a complex transaction through financing, through underwriting, through appraisals, through clearing title, that the form of vesting is something that is not really in the forefront, or it's not given the time of attention that it ought to be given. Because as you point out, Voltaire, there are tremendous consequences, significant consequences on the back end with the form of ownership. So form of ownership is again something that most title holders don't give it much thought, because I'm not really sure why that is, but the form of ownership can affect asset protection. Form of ownership can have tax impact. Form of ownership could have impact in terms of if you're in collaboration with an investor. And form of vesting also affects legacy issues. So in the moment of closing and in the moment of vesting, there's a lot of things that must be thought through in order to make an intelligent decision about title. I'll jump to the very end here at this point to give you my bottom line punchline. As we go through all of the different forms of vesting and how to hold title, in my estimation, that the superior form of title holding is in a trust, period. There is, in my estimation, no superior form of title and vesting than in a trust. Because by way of vesting and titling in trust, you have maximum control, and you can address the downside of life happening. And this is so even in the instance where you hold title in an LLC, or you hold title in a corporate entity. When you hold title in an LLC or you hold title in a corporate entity, you want your corporate entity to be registered to a trust. So it ultimately falls back to the most superior form of vesting and title is in trust, either directly in trust and or in an LLC or corporate entity or partnership, and have that entity or your membership interest in a trust. So I'll stop there to sort of put that out there without going into too much detail as to the nuance of the difference between tenants in common, community property, with right of survivorship, without right of survivorship. I have war stories from my trenches, a great many, where title has made all of the difference in terms of a consequence or an outcome. So I'll leave it at that. And I mean, I can speak for hours on vesting and ownership. I certainly want to respect, Voltaire, how you want to have this.
Yeah, no, I think it's a perfect segue because you just mentioned, you know, the war stories, and ultimately you just got straight to I guess the issue at hand, or to the main point, which is what's the best way to hold title, and that's in a trust. So right now I want to start us off with the normal transaction, because a lot of us are normal people. Yeah, there's some of us that own a lot of real estate, and maybe it gets a little bit more complicated, but the normal person, the way it works is we buy a home to live in, right? And when we're in escrow, the escrow officer says, how do you want to hold title? And they send us this document, which I'm going to share with you guys right now. And so I want to introduce Jeremy so he could go over this document with us right now, and that way he could kind of give us the definitions of this document. So I'm going to pull up a document right now, Jeremy. So Jeremy, introduce yourself. Tell us a little bit about yourself and your background, please.
Guys, how we doing?
Oh, we can't hear you. If you want to just speak a little bit.
Hear me now?
There we go.
No.
There we go. We could hear you now.
Okay. How we doing, guys?
Doing good, man. Blessed.
I got the COVID beard. I apologize. I just, you know, I mean, I haven't been getting out as much. Well, first of all, thank you for having me on. And number two, I applaud you, Voltaire, and everyone for having Pablo on, because everything he said so far, coming from a title perspective, I agree with 100%. I think that depending on, you know, and again, I would defer to your tax professionals, but also to your estate planners like Pablo. When you're making these decisions, we've made a beautiful worksheet, which I shared with you guys. And I'll tell you, before even looking at that, I would talk to your tax professional and your estate planner, and get, everyone's so different in their financial holdings, their estates, their assets. So I recommend that you talk to those two professionals before you make this big decision, because it is a big decision. The ramifications, as Pablo alluded to, are huge. I can't tell you how many properties, and right now especially, are coming out of their trusts and then into a, say, a husband and wife, and then they forget to put it back, or a lot of things can happen. And then God forbid someone passes and, oh, we forgot to put it back into the trust or vest it properly. And now we're talking about a probate situation. It's a sad tale, because they had every intention of having it in the trust and protecting their assets. But for whatever reason, their professionals in the mortgage industry got too busy or whatever, right? It's, you know, ultimately it didn't happen. And now they're facing their, you know, the governor's going to take their cut of their assets now, even though they had the intentions of covering their assets, right? So to go back, I agree 100% with Pablo. If you are protecting all your assets, then having it in a trust is the best way to go.
Okay, so you brought up an interesting point, which begs the question. You know, there's people that buy real estate and they don't consult, let's say, someone like Pablo, when holding, you know, as far as how to hold title, or they make a lot of transactions, meaning they make a lot of movements within the title, like, oh, I'm going to add my son, I'm going to add my cousin, I'm going to add whoever, and off and on. So what was the biggest issue, or the biggest reason why people don't do that? I actually consult with someone. Is it the money part of it? Do they just not know?
Oh yeah, well, it's a great question actually. And you know, I'd like to hear Pablo's take on this, but before he says anything, the ultimate thing is that sometimes you don't want right of survivorship on a property, meaning, let's just say you and I hold a property together, Voltaire, and we hold it as joint tenants, right of survivorship. So if I were to pass, you would get ownership, right? So there are some investors, partners out there that don't want that necessarily to happen. What they want to happen is that whatever their ownership and interest, say it's 20% Jeremy, 80% Voltaire, is passed on to my descendants or to a different party rather than to you, Voltaire, only because they want their assets given to, whether it's to a business or to their family. They don't want it to go to their partners on the transaction. So I see a lot of tenants in common because, say there's 10 owners and they all have 10%. And so they want to hold it that way so that they can dictate what happens after the fact, right? So that's an important reason. And I defer to Pablo on why he sees other ways. Obviously, I see a lot in California. We see a lot of domestic partners. Now, mind you, one caveat on domestic partners, you do have to be registered with the state. So I'm sure you guys know that, but it is important before you can register as, domestic partners. But maybe they, even as domestic partners, they don't want their interest to go to their partners, say, right? So that's where I think different ways to hold title comes into play. But I will say again that the most common way with people with pretty sizable estates is to hold in a trust.
Okay, cool. Yeah, so we'll segue right into this, and Pablo, if you want to kind of dive into this ways to hold title, this is something that Jeremy has given me in the past, and this is something that we actually send to our clients. Well, usually Escrow gives to our clients saying, hey, these are the different ways to hold title in California: community property, tenancy in common, joint tenancy, tenancy in partnership, community property with right to survivorship, title holding trust. I'm not sure if this is the most updated one, but on the left side, it tells you who the parties are, the name of title, the division of the interest, conveyance, how are you able to convey, the possession, what happens upon death. So all these things. So, we don't have to go specifically into each one, but Pablo, do you want to just kind of go over what's the most common ones that you see, and then maybe you could even touch on why people don't consult an attorney right off the bat. Is it the cost? And if so, if most people say, hey, like I barely had enough to buy a house, I'm not going to spend more money for another consultant, for an attorney to tell me how to hold title. What do you think about that? And if that's the case, can you break down some of these that way people know what currently they do hold it in, probably most likely, and what they should do about it?
Yes. So to the first sort of general question, which is, what are the barriers in having great information so that people can make an appropriate decision as to how to hold title, right? That's sort of like what's happening that people aren't thinking through this. So my estimation, the following: one, the market for real estate professionals, there's all kinds of levels. There are the sophisticated advisors like you, Voltaire, who, you understand, you go above and beyond, and you push your clients to ultimately do the right thing. I mean, I can't share certain things about our relationship, but I know that you know how to advise people and how to motivate and encourage people to do the right thing with regard to their estates. Most real estate professionals don't do that. They don't go the extra step to really push and champion that the client handle this piece. Most real estate professionals are like, I get paid at this point of the transaction. Here's a sheet, good luck. So you have fulfilled on your end of the bargain and you have provided the information. Arguably, you're done. Then there are professionals like you, Voltaire, who go above and beyond the call of duty and really champion that the clients take the next step. So one barrier I would say is that some real estate professionals go above and beyond and others don't, right? So that's one. And we clients on the ground rely on guidance of the real estate professional. I think that another barrier to getting proper advice is as you point out, Voltaire, there's this perception that I can't afford counsel. In my view, it's it's more expensive not to get counsel than to pay for counsel. Because in the long run, you don't want to be penny wise and pound foolish. So I think another barrier is a value perception. It's not worth my money and time to get counsel. It's expensive. So that's just on the end user. Different people have different sensitivities to investing in counsel. The other barrier that I find, and Jeremy, you kind of alluded to this, is a perception that only the rich require counsel and input from counsel. And I think that's a very common perception. Now, the rule in probate is if you have more than $50,000 in real estate, you have a probate liability.
What's probate?
Come again?
What's probate? If you could give the definition.
Yeah. In a nutshell, you have a dead person and you have title in the name of a dead person and you can't move that asset. So then we need to go into a court process called probate, which derives from a Latin term, which means to prove, probate, to prove ownership. So the short answer is what's probate is anytime you have a lapse in ownership, because the person's incapacitated or dead, then we need to seek the jurisdiction of a probate court to issue letters so that we can control the asset, right? So it's a lapse in control.
Right. And we want to hear one of your war stories before this is over, but I'll just give everybody just a quick anecdote. So I get a lot of phone calls over the years from people that say, hey, my dad passed away, whoever passed away, I got this house, I want to sell it. And then I look up the title and it's still under their pop's name. It wasn't in a trust. It wasn't any other type of entity that would allow them to sell. And I go, dude, you can't sell it. The state's going to take control. It's going to have to go through probate. It's going to be 10 months. It's going to be thousands of dollars. And then that's when I hook them up with an attorney like yourself, Pablo. So just so everybody knows, that's real. And then that's usually how it works. What percentage of people, Pablo, do you think have to go through probate because they don't have their estate set up in the proper way?
I mean, that's a good question. The statistics really in terms of proper planning are in the 60+ percentile. So if we sort of extrapolate from that and imagine that 60+% of the population hasn't done any planning, and then you add in some of the elements that Jeremy was talking about with multiple transactions, property moved in and out of trust, you're probably looking at in the 70 percentile range. I think sort of the final barrier that comes to mind is you look at this wonderful spreadsheet that, I look at it and I'm like, oh, beautiful, 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 get it. But this is what I do for a living. Whereas if you're as you're saying, Voltaire, a lay person, like, what the heck does all of this mean? It's information overload. What's the thing that's the easiest? And so there isn't a whole lot of thought. There's information overload. As to the options. The barriers would be
add something you're bedazzled and you're baffled by the whole process when you're doing it for the first time. You start throwing all these legal terms at people, and all they're trying to do is they understand that it's better to own than it is to rent. So escrow doesn't mean anything less than title. Title doesn't mean anything more than underwriting. They don't even understand the differentiation between the different processes. And I just think that a lot of people don't know what they don't know. And, I know that was my experience early on until, so, and what you don't know ends up being used against you. Like just a simple thing I'm dealing with my mother's trust right now, step-up value. We're getting a real hard lesson in step-up value if we were to take something out of that trust. So it's interesting, and this is why you're right. You should pay for this knowledge. It's penny wise.
That's a great point. I would add what you're talking about. I don't know if that was Dennis who just spoke. You're talking about blind spots, right? So you're talking about what you don't know. That's a blind spot. So if we look at this wonderful spreadsheet here, I mean, I look at any category, and any category has consequences in terms of legacy ownership, in terms of rights of survivorship, in terms of control, in terms of, like for instance, I have many war stories where if you look at the first column there where it says community property, and then you move over to the second to last column that says community property with right of survivorship, huge difference. So I've had many a war story where we have a dead spouse. The living spouse is on title, they were on title as community property. We have a dead spouse, but there was no language with right of survivorship. That's a probate. With right of survivorship, 4 words missing is a multi-$1,000 consequence in a probate process. You know?
Got it. So that means that, so what does that mean? One spouse died and then the other spouse didn't get their portion?
Correct. So the living spouse, so what happens in a community property, each spouse is able to bequeath, inherit, gift their community interest. So when you have with right of survivorship, you indicated on title that upon death of either spouse, the survivor keeps the whole. Whereas if you have simply community property, without that language, at the death of either spouse, that community property interest of the deceased spouse at that point must be probated, because there's a lapse in control. There's that lapse in control concept that forces us into probate.
And then when it comes to a probate, what could happen? Does that mean that, let's say husband, wife, and let's say the husband passes away, the wife says, okay, I'm going to inherit the property, it's my property, but then all of a sudden, those 4 words were missing from title, right, with right to survivorship, and all of a sudden, let's say a nephew or somebody in the family says, no, wait a minute, you know, Pop said he's going to leave it to me, his portion, and all of a sudden there's like a legal battle between the wife who spent, you know, all these years together and it's her property, really, and all of a sudden somebody else comes in the picture and says, no, I'm gonna put my 2 cents in with the court, and I'm gonna take 50%. I'm gonna force you to sell the property so I could get my money. So is that something that could happen or has happened?
Absolutely. So if you have a community property interest and you have a wife, one spouse, it all goes to the spouse by probate. If you have a community property interest and there's a spouse and a child, half to spouse and the other half to child. If you have a spouse and 2 children, then of the half of the deceased spouse, the living spouse gets 1/3 and the 2 kids get 2/3. If there's more than 2 kids, it's 2/3 for the remaining beneficiaries. So the community property interest of the deceased spouse divides according to who survives the decedent, right? If it's one wife, one way. If it's a wife and a kid, another way. If it's a wife and more than 1 kid, it's a whole other ballgame.
Wow. So basically what a trust does, it allows you to plan, hey, this is what I want to happen upon my death. I don't want, you know, I want my wife to have it. I don't want my kids to mess around with it, especially, you know, because, yeah, you guys worked for it, earned it, paid for it, and then all of a sudden everybody gets their hand in the cookie jar and potentially causes them to sell. Would something like that happen in order to satisfy everybody?
Correct. So when you have assets vested in trust, a trust is at its core, it's a contract. And the trust as a contract dictates what happens to the assets inside of the trust instrument. Or if you think of a trust as a strong box with instructions, technically it's a contract, but just imagine the strong box with instructions. So when you have the trust, the strong box indicates precisely where the assets would go. So you have greatest control on the front end because you typically trusts are revocable. You have complete dominion of the asset. And then upon an event happening, then you have the flow of that asset going according to whatever the instructions might be.
Okay. All right, cool. And by the way, guys, as you're watching this and listening, you could ask questions in the chat box. So you could just write in a question. We'll look at it. Or you could also raise your hand and, you know, we could talk. Okay, so going back to this, what's the most common thing that you see as far as people holding trust, like, you know, as soon as they close escrow? Which one do they usually choose, or as far as husband and wife, number one, and then the other one is just, you know, a person by themselves?
Yeah. So with husbands and wife, I think I primarily see joint tenants, but I've also seen community property with right of survivorship. What's the difference? It's a tax consequence. Dennis earlier was talking about a hard lesson in cost basis adjustment. What does that mean? So what's the difference? So you're a husband and wife. If you hold title as community property with right of survivorship, at the death of either spouse, the entire asset gets a full cost basis adjustment. So, you know, capital gain is paid on the difference between your cost basis and your profit. If the surviving spouse inherits property by way of community property with right of survivorship, all of the capital gain that's built into real estate is eliminated at the death of one of the spouses. So it's a tremendous tax consequence when spouses hold community property with right of survivorship. So I typically,
Wow.
I typically default to community property with right of survivorship when we have married couples. That's my preference default, assuming the entire estate is community property with right of survivorship. However, more common is joint tenants. Oh, okay, so if I die, it goes to my wife, or vice versa. Very common, more common than community property. And then, but there isn't that exploration of the tax benefits upon the death of either spouse. So joint tenancy is what I see more regularly with married couples. I also see this. I also see that with, like, if you and I, if between two unmarried persons, I also commonly see joint
Can you
tenancy.
say that again? I missed a little bit of that. So the joint tenancy is what most married couples get, and it does or it doesn't protect them from a tax liability standpoint.
So husband and wife hold as joint tenants. One spouse dies, there is a partial step up in basis. Whereas if a couple holds title as community property with right of survivorship, there is a complete and total step up in basis. So from the perspective of tax basis at death of either spouse, the superior form of ownership is community property with right of survivorship.
Wow, that's amazing. Yeah, that's a really good thing. Again, Coach alluded to it earlier, is that, you know, you don't know what you don't know, and it could cost you big time. You know, that right there is a lot. And a lot of people I know on there don't know what cost basis is, don't know how capital gains might work. And we don't necessarily have time to explain it in this workshop, but just know that it's a huge tax benefit, what Pablo just explained between those two. So that's something good to know. Okay, so that's what you see a lot with married couples. What about non-married couples? I mean, not couples, just non-married people.
Yeah, so I usually, you know, it's a mixed bag, but here's what's really important. And anytime you are in some type of partnership with another title holder, because you pull resources together, because you need someone to co-sign with you, it's important to have this conversation. Should we hold title as tenants in common, or should we hold title as joint tenants? Okay, so let's say, Voltaire, you and I, we invest in a piece of property here in Sherman Heights, and we're like, all right, let's just close escrow joint tenancy, forget about it. We don't really talk about our different options for ownership. If I die before you, Voltaire, that property is yours. So my wife doesn't get a piece of it, my children, it's completely yours. You have rights of survivorship. However, when you and I go into this deal, I think the thought is, if I die, I want my family to inherit my portion. So what we should have done is to hold title as tenants in common. Okay, so what's the difference? When two or more people hold title as tenants in common, any one of the parties can determine where their ownership goes at their death. So in a tenants in common, you don't have a right of survivorship as to the other tenants. And there's probably, yeah, so if you look at the column tenants in common, and then to the left you look at death, that'll explain to you the consequence of tenancy in common and joint tenancy. So to your question, Voltaire, with regard to more than one person on title that are not married to each other, this is important that people think about this, because on the back end, your portion of that asset might end up in the hands of the living owner unintentionally. So very often when we do estate planning and investors come see me, the first thing we need to do is what we call sever title. When we sever title, we're changing the form of vesting from for example, joint tenancy to a tenancy in common. so that each of the parties can then determine where their respective interests would go. I think I often see more joint tenancy than tenancy in common between parties that are investing together and they haven't put a lot of thought into it. Yeah.
Yeah, that sounds, man, Jeremy, what do you see? Do you see a lot of joint tenancy over tenants in common whenever it's like partners like that, or brothers or sisters that are buying together?
So a lot of family people, I see joint tenancy, right? A lot of partners in investments who are both individually invested, right? And, you know, obviously there's an affinity to those folks, but they don't want to see their interests go to their partner. They want to see it to their loved ones or to a specific person. So I think Pablo explained it pretty eloquently that that's the difference there, right? That's where do you want your interest to go should you die? So I see a lot, most of the time I see joint tenancy. So, and a couple things I wanted to add just from a title perspective. Hold on to your trust, guys, because the number one reason why we can't close a lot of deals in title, even when you have it in a trust, is because no one can locate the trust. It's 30 years old. The attorney is nowhere to be found. And so there is a great thing called a trust certification done under penalty of perjury, but that's not always going to be a quick fix for you. So hold on to that paperwork. It's very important. Another thought I had earlier is to the conflict that we see from the perspective of title. Whenever something's not held in a trust and the owner passes, that's when we see the biggest conflict, because we see the cousin say, oh yeah, the deceased said it was my property. And then you have the sister or the sibling, or excuse me, the kids, whatever it might be. And it just creates for a lot of consternation with the family that I've seen. So if you can advise your clients, the trust is the cleanest way to describe to everyone after you leave this earth what you want to happen with your estate. So to avoid a lot of conflict with family and folks, I think that's the best way. We see a lot of it. The second thing is keep your trust, keep copies of it, give it to all of the successor trustees, make it known where it is, because that's an important document for a title company to pass interest to the purchaser, right? And a lot of times you'd be amazed how many times it's passed on, right, from generation to generation or whatever the case, and there's no trust to be found. And some folks have trouble signing a trust certification under penalty of perjury because it's not necessarily 100% clear what the deceased intended. So anyways, those are just two things that I see from title. And what I brought up earlier, especially pertinent today, is when you take, luckily a lot of lenders are not required anymore, but some are. When you take it out of the trust to do the refinance, make sure that you have a clear path on putting it back into that trust, because as Pablo can tell you, it doesn't, there is a way to speed up the probate process, and I forget the exact name. You probably know, Pablo. It's some kind of act or something. But with all that said, you still have to go through a process that you could totally circumvent if you have it back in the trust.
Yeah, that's a good point. One of my friends recently wants to sell their property, and he can't locate the trust. And he reached out to the attorney who did it back in the 90s. That dude passed away. So the attorney passed away. So then he's talking to the secretary, and the secretary's like, I don't have a copy of it. So that's a good point, Jeremy, is that whatever documents you have that show ownership or whatever, when it comes to a trust, like keep it, keep it safe. I don't know, should they share it with someone, Pablo? How does that work? Because I know you keep records I'm sure, but what happens if something happens to you, or you decide to, you got enough money and you want to retire? I mean, what happens? I mean, who keeps copies of that trust? Who should they share it with?
Yeah, great point. So, Jeremy, the process that you were talking about is called a Hegstat petition. A Hegstat petition is where someone's dead and a property was accidentally left outside. We're now practicing we're in a whole, I was reflecting with my wife, it's like, I can't imagine practicing law 20 years ago, because in this environment, everything's in the cloud and everything is digitized. So in my process, whenever we prepare documents for clients, they keep the originals and we digitize everything, and the client has a digital copy. In addition, I require that my clients come in at the very minimum every 7 years for a review meeting. And in a review meeting is where we hope to capture what Jeremy's talking about, inadvertent movements of assets outside of trust, or updating what's called a schedule of assets. So I think it's important that as you vet the attorneys you may work with, you ask this question that Voltaire asked, like, what's your process for digitizing? Attorney, what's your exit strategy? What I tell my clients is I can die tomorrow. I don't need to be holding on to originals. I think no attorney should ever hold on to a client's originals. I think the client should hold on to the originals, and the client should have a digitized copy. And at the very minimum, at least the successor trustee ought to have a digital copy. I don't encourage more copies to be distributed than that, because over time, your favorite person might all of a sudden not be your favorite person, and you might want to make changes, and you probably don't want them to have copies of these things. But at the very minimum, you want your successor trustee to know that there is a plan in place. I have a digital copy, and this is my counsel. So I often get calls from the successor trustees, and we have a digital copy. So I don't think in this environment there's any reason why an attorney would not digitize a client's documents for ease of use, for posterity, etc.
Good. Yeah, thanks for that. I know that, right now we're talking about, successor trustees and different topics. So the main point, I think, because this title process is super complicated. It's not like an easy thing, right? I mean, we're looking at this, what is this? This spreadsheet really with information on how to hold title and pros and cons and what happens, upon death or conveyance, etc. So I think we all got the point there that it's super important to hold title in the right way. How about, Pablo, you mentioned successor trustee. Can you quickly break down how a trust works, different terms in a trust, can you kind of break that down real quick? That way everybody kind of understands these words that you just used.
Yes. So again, I like pictures and metaphors. Imagine that your trust is a strong box, okay? And every trust has 3 positions. There's a position of the trustee, the position of the trustor, and the position of the beneficiary, okay? The trustor is the person who creates and designs the trust. The trustee is the person who has authority to manage the assets inside of the trust. And the beneficiary is the person for whose benefit the trust assets are held and managed and protected. So oftentimes, so for example, my wife and I, in our trust where we hold our real estate, we are the trustors, we created it. We are the trustees, we manage it. We are the beneficiaries, it's for our benefit. So we're what I say, we're the holy trinity of the trust instrument, right? We're the trifecta, we're the owners, the designers, and the beneficiaries. When we die, we're still the trustors because we created the thing. At that point, the trust is irrevocable. Somebody else steps in as a trustee, so somebody else is now going to manage the assets. And the beneficiaries become our minor child and children. So upon an event happening, the positions sort of shift. Now we have a dead trustor, a different third-party trustee, an adult, and beneficiaries who are minors. So if you can hold in mind that trifecta, I think it'll give you a solid understanding of how this instrument operates. And oh, by the way, a trust strong box can hold title to real estate, to corporate interests, typically would be the beneficiary of life insurance, would hold title to bank accounts, would hold title to investment accounts. So the concept is that once you have your strong box in place, you want virtually every asset you own either registered to it or somehow related to it. And I'll put an asterisk on that because if for every family it's different, but by and large, that's really the concept. You have a trust, everything in trust, you control it, you're the beneficiary, you're the holy, again, Trinity during your life and capacity.
So like a quick example on that, guys, is I've seen people pass away, and then the kid's like, oh, how am I gonna get the money in the bank? And then they're like, they have a debit card of their mother, and they're like, sure, what's the PIN? They find the PIN, then they just like take out, you know, $1,000 at a time or whatever the ATM allows them to take out, because again, that bank account wasn't in the safe box, like you call it, inside the trust. Therefore, they may have access to the real estate to sell the real estate, but what about, you know, the bank accounts? So that's a good point to know there. So basically, in short, if you put all your assets, right, into a trust, then whoever you designate inside that trust could basically have access to all your assets. So can you give us like one of your war stories with, you know, parents and children, and, you know, maybe the parents, you know, leaving some children out, or however they structure their trust? Because in essence, you could tell everybody upon your death exactly how you want your assets distributed, right?
Correct. I mean, you know, you can virtually provide any rule of access, any rule of engagement with the assets to your children that is legal. And I've been involved in many a creative circumstance. Here's what's interesting. I often find that there's a child who stayed back and is taking care of an aging parent who has made a lot of sacrifices, and then there's no plan in place. So often you see the misfortune of the child who should have received the asset now is forced to share assets with all of the family members when that was not the intent, right? So I've seen a lot of those scenarios. Or the other thing I've often seen is where, you know, mom has a lot of what we say confianza, really trusts one of the children and says, okay, I'm going to leave it to Juanito, who's going to take care of everyone. Well, it turns out that Juanito is a little more greedy than we thought, you know, at first blush. Or it also turns out that Juanito might have some child support in arrears, or all of a sudden Juanito is in a divorce proceeding, right? So, you know, I see a lot of the stories from the trenches in my world have to do with a lot of doing it how the vecino did it, or doing it no pasa nada, or it's not gonna happen to me. Just a lot of heads in sand with regard to this delicate topic, which is death. You know, yeah. I mean, I just have so many stories. I do want to share something that is important here. Not all trusts are built the same, right? So I liken it to cars on the road. There's all shapes and sizes, and there's all different features. You get what you pay for, okay? And there's a difference. A trust from one attorney is not the same as a trust from another attorney, and working with a paralegal can have dire consequences. I'm saying this to illustrate one point that I think is a good takeaway in this community. So you guys are familiar with the Parent-Child Exclusion, right?
I am, but if you want to go into it.
Right. So if my mother leaves me a piece of property through the Parent-Child Exclusion rules, I'm able to pay the same property taxes as my mom. Right. So if my mom bought a house in the 60s for $20,000 and now it's worth $1 million, I inherit it when it's worth $1 million. I'm paying taxes from the 60s. That's thanks to the Parent-Child Exclusion. Very powerful rule that oftentimes is blown when assets are transferred by way of a trust, because the trust doesn't have the language to preserve the Parent-Child Exclusion. And the trust doesn't have the language because not all trusts are built the same. The client chose the 99.99 legal Zoom trust versus the 3,800 Pablo trust, right? There's a difference. So
right.
Where property goes, let's say mom leaves a house to 4 kids. right? And then one kid decides to buy the others out. When that one kid buys the others out, the kid is going to get reassessed by 3 because he's purchasing the property from siblings. And so that there is no parent-child exclusion from there. However, if the trust document has specific language to preserve the parent-child exclusion, then you can have a result where the one child can buy from the others and preserve the parent-child exclusion fully, right? So this is something that I learned the hard way in the last 5 years of my practice. So even your seasoned practitioner might not know the trick. So get a trust, get it done, and get it done by the right people. And these are things that you want to ask as you go through the process of constructing your entity.
Yeah, that's a good point, because like you said, they're not all created equal. We only know what we know. I know that for many years I was creating and tweaking my own trust, thinking I'm smart. And once Pablo looked at it, he was like, "What?" He looked perplexed. He was like, "What?" It was funny, but I didn't have that language in there, and now I do. So that's something, a good takeaway. Now, somebody asked, "Hey, how do I know the property that I own? How do I know what type of title that I'm holding? How did I take title to my home?" Good question from somebody that already owns a property. And Jeremy, I'll go ahead and let you chime in on that one. I can't hear you, Jeremy. Can't hear you. Jeremy, we can't hear you. There, unmute yourself. I could unmute you. Let me see here. There we go.
Sorry,
can you
guys.
say
Yeah,
something?
great question. So a lot of guys, folks, owners get these terms confused. There's a vesting deed, which can take form in a grant deed, a quitclaim deed, others in different states. But in most cases, it's a grant deed and or quitclaim deed. If you're confused as to how title was taken, just ask me for the vesting deed, the most recent vesting deed, and that will tell you how you took title. Right on the front page, it tells you, front of the grant deed, the document, it will tell you how you're holding title today. Along those lines, and Pablo alluded to, some guy with say a spousal lien or tax lien. Keep in mind when you are taking title, number one, we're in a community state. So when you get married, your significant other now has 50% interest in the property. So I see a ton of issues where, oh, well, we got a court order, it's my property, but there was no document that actually transitioned the title back to that person. And so now you have to get signatures from the ex, which can be very difficult, guys, if you've ever experienced this. There's a lot of unhappy divorcees, right, that won't sign that, or maybe they'll sign it with some incentive. But with all that said, keep in mind when you get married, we are in a community property state. The other thing is when you're adding and subtracting people from title, you're also adding all their baggage. So if you add Uncle Jerry, who has a $50,000 tax lien, you just inherited that on the property as well. The minute he takes title, so do all his liens, right? So say you and Jerry own a property and you go to refinance, well, that $50,000 tax lien, let's say, needs to be reconciled before you can close the refi, whether it's paid off, negotiated, whatever it might be. Very, very important. And one other thing I see come up a lot in speaking to Pablo's point about the different types of trust, right? I see a lot where there's no allowance for a POA, power of attorney, within the trust, right? Which could have a huge bearing on, say that the person is incapacitated and cannot sign under his own volition, right? Or her own volition. So to Pablo's point, and another good reason to get with a great trust attorney like Pablo is you got to look at all of the different nuances within the trust and make sure that it's created for you and your needs. Because all of these nuances if they're not addressed early on, when it comes down, push comes to shove, and there's no allowance for a POA, a power of attorney at the last minute, there's issues. There's issues with passing title. So again, to answer the question, just ask your title rep or your title company for the last vesting deed. That will tell you how the property is held today.
Yeah.
So if you want to double check with all your clients, whether they're back in the trust, it's a great way to have a conversation with your customers. And then those other little hurdles, caveats, make sure that when you get married, you address it with your significant other, and you can do an interspousal deed, taking them off title after the marriage, which gives you full interest, right? You can do, there are measures you can take. And again, get with Pablo on all the nuances of a trust, because it can be detrimental to your end goal, and it can be detrimental to the goal of the person that's incapacitated and or unable to sign, right? So the goal of the trust, again, is to absolutely give the wishes to the deceased and or in this case, incapacitated.
Yeah, great point. So to answer that question as well, so just reach out to your favorite Lepe Tendwell real estate agent, ask them how you hold title, and then from there, the agent will reach out to Jeremy and get that information from you. So thank you there.
100%.
Yeah, and then there's another question. Do you recommend clients that are in escrow buying a home to speak with an attorney to fill out the preliminary change of ownership and title vesting? Pablo, what do you think?
So I'm a believer in, again, I love this topic of blind spots, right? And I love the topic of having a cabinet, like, you got to have your go-to real estate professional, your go-to tax person, your counsel. So in a perfect world, you're surrounded by your cabinet, right? And so this is the context of answering the question. So the short answer is, do whatever you need to do to close the deal first, right? It's because oftentimes you have to sort of do things unique for underwriting, et cetera, but be mindful and committed of what you need to do after you close the deal. Because if by your form of vesting is going to affect your deal, then you're kind of not really interested. You're more interested in closing escrow than anything, right? So this is to say that it really depends on the circumstances, but I would say that person going through escrow, you don't necessarily need counsel to evaluate the preliminary change of ownership form or vesting in that moment. But do be mindful that if it's not in trust, that you need to follow up, right? Because I've often told people, get through the deal first. Once the transaction is complete, we'll get together and we'll do a quick claim deed to transfer that asset into trust. So you can do things after the fact so that you have the best of both worlds, right?
Yeah.
Awesome. That's how I was.
Yeah. And to touch on that answer, I just added up the pages in my trust, 133 pages, 133. So what does that tell you? That means that there's a lot of blind spots that we just don't know about when holding property to real estate. And we should definitely, in my opinion, because usually you sit down with the notary, the notary says, oh, check this box if you want community property, check this box if you want joint tenancy, check this box if you want this or that. And there's no real counsel. And I think it's important. I mean, if you're buying a $500,000 home, what's an extra, I don't know how much you charge, but, a few $100. I think it goes a long way. Somebody else asked, can you change the type of title that you have on the property that you own? Yes, you can. You could change it. Again, you get with your counsel and then choose what's best for you after you find out what you have. If you want to add a trust, you can. And then this is a question from somebody else. How do we begin the process of a trust after we purchase one from LegalZoom? So how does that work? If somebody already has a trust or somebody already has title or whatever, what's the next steps like with you when they reach out to you, Pablo? How does that work? What's your process?
So if you remember that the trust is a contract, and you can always modify a contract. So you can always modify your ABC LegalZoom trust to make it a more robust trust. So the process would be, most trusts have a clause in there that allows you to amend, right? So a trust restatement is an amendment on steroids. So you can take a very simple boilerplate LegalZoom trust and make it into this ginormous, robust trust without having to change the vesting or the title. So if I create the Pablo LegalZoom Trust 1997, I would restate it and it would still be the Pablo LegalZoom Trust 1997, but with all of the bells and whistles. So you don't have to start from scratch or new in terms of retitling and refunding. You would just simply overhaul the internal components of the trust. So you take the engine apart, you rebuild it, you put it back into the same chassis.
Got it. And do you need to give do you need to record that on title, like an updated copy of the trust, or no?
No, you don't.
Okay. All right, cool.
That's one
How
other
can I?
quick point, guys. A trust is not recorded. So that's another reason why I keep your trust, because we don't record it. So when you do a trust, it doesn't get recorded with the county recorder. It's just for your own records, right? So
Got it.
a lot of people ask me can you pull the trust on it? And unfortunately we can't. So I thought it was recorded when I first got in the title myself, and it isn't a record. So just keep that in mind.
Okay, cool. Yeah, and that makes sense. So the government doesn't need to know what's going on in your trust. You could always amend it and change it, and nobody needs to know. Great. So it's private there. A few more questions. How can I check if my property is free and clear of liens? Again, reach out to your favorite Lepe Tendwell agent, and then we'll check with Jeremy and his company, and they can check that out for us. A popular question here is, what's the cost to switch into a trust? So what's the ballpark cost for a trust, Pablo?
You know, this is a great question because the market, there's such a wide range of offerings in the market, from a do-it-yourself to the LegalZooms to the paralegals to the lawyer trust mills to the high-end. I mean, estate planning, by the way, a trust is only one document in an estate plan. So when we talk about trust, I'm really thinking estate planning. So, you know, I think the good planning begins at the $2,500 level and above. Under that, you're really in a mill. You're not given the time in the process that the process requires. In my world, I'm averaging between $3,000 and $5,000 is the range for estate planning, which again, the question is, what does it cost me not doing this, so that you can really compare? Because what people are doing is they're investing in an intangible. The investment is into a peace of mind of knowing. It's not like you spend $4,000 and you can hold on to the thing. Here you're investing in the knowing of a future event. So
yeah,
wide range.
Yeah, so you could.
And
you know,
if I can add something, you know, when I put my stuff in a trust, which was probably 5-7 years ago, it was $1,200. So I would tell you, a good attorney is going to charge you somewhere between $1,200 and $1,200 to $2,000 to put everything and take care of it. That's my 2 cents.
Yeah. So it all depends too on, you know, how many assets you have. And there's a lot of variables that go into it. And again, a lot of times it's, you know, you get what you pay for, but there's all these things like that people don't consider. It's like, okay, the capital gains thing, right? The child parent exemption. I mean, if they reassess your property from paying, you know, $500 a year in taxes to $5,000 a year in taxes, that's $4,500 that you just lost because you didn't plan your estate correctly. So you want to make sure you have those little intricacies that a lot of us don't even know exist, don't even think about, but an experienced attorney would know. So Coach, you had a question about two people that just bought a home or entitled to their home. What's the question there that you have?
Okay, I have a buddy of mine who just put like a ADU on the back of a buddy's house. Okay, and the guy he did the work for has got early onset dementia. Okay, and they just signed a loan on Monday they have joint tenancy. So I'm thinking this property probably should be into a trust, because I don't know what's going to happen with the one person, you know, as he gets a little bit more elderly. You know, so I was thinking that I should probably tell them they should put the property in a trust so there's no ifs, ands, or buts about it. Because I was, you know, it's joint tenancy now. And the other person who did the construction, he's got a son, you know, who's like 30 years old. So I'm sure he would want that property to go to his son. I imagine that the contractor's going to outlive the person he built the addition to, and they're friends for 30 years. They were in business together, and you know, the first person was really happy that the contractor stepped in and helped him out with all of his finances. So it's kind of
Got it. So yeah, it sounds complicated. I think the question I have is, can you even make an amendment to trust when somebody does have dementia? What do you think, Pablo? What's your experience there?
So Jeremy earlier today talked about a POA, power of attorney. So in this situation, if there's a robust power of attorney in place, then the family of the, we'll call it diminished capacity person, can sever title.
He's only by himself. He has nobody else. That's why my buddy stepped in. So he has no survivors. His wife is dead. So it's him and, you know, two of his best friends taking care of him.
Yeah, that's a really complicated, because the question is.
All right. I'll have him investigate it, because I'm thinking, you know, everybody's interests have got to be protected. And,
right.
You know, they're doing everything on a handshake and friendship, but, you know.
Yeah. So the long and short there is, what is the intent of the diminished capacity person? And so we may never know, but so to give you the long answer is, when you don't have proper planning in place, there's this thing called conservatorship, also known as living probate. So if perhaps the thing to do here is do nothing. I mean, quite frankly, if the gentleman doesn't have any heirs at all, maybe the best outcome is, you know, do nothing and give him the quality and dignity of life by virtue of friendship, you know. But there's very little that can be done when you have diminished capacity persons and you don't have relatives around that individual.
Right. Okay. Thank you.
Right. Yeah. Thanks for that. Any other questions before we wrap this up? You know, I learned a lot today. I've been doing this a long time, and you know, there's all these nuances that you just don't know, don't know exactly how they work. And even though we're all real estate professionals, not all of us, there's a lot of regular folks in here that aren't in real estate. You know, you forget some of this stuff. So that's why we got to have our advisors, and, you know, you got to have your real estate advisor, you got to have your loan advisor, your estate planning advisor, financial, etc. Right? So I think it's very important for all of us to practice this in our own life. And if we do have clients that, most of my clients, they buy and they just, again, the notary says which box you want to check. They read off, you know, the little spreadsheet that we just looked at. They go, oh, I want to go with this, you know, community property. Maybe they forget the right to survivorship, you know. So, and I know a lot of people that just say community property because they go, well, you know, I want to choose who I want this to go to, but they don't think about that step-up basis that they could get, you know, potentially just murdered on in taxes. So I think it's important to have our advisors. And a couple of questions here I just popped up is, what about LLCs? Can you purchase your house under a trust? Yeah, good answer there, Pablo. You could definitely buy it in a trust. You just got to get past the lender and all their requirements. So we didn't cover the other ones: LLCs, corporations. Any 2 cents there you want to put in, Pablo, when it comes to LLCs and these other, you know, partnership agreements and all this other stuff?
Yeah, just to reiterate that if you have ownership in an entity, then you want that entity to be owned by the trust. So if I have my property in an LLC, my LLC is owned by the trust, therefore that property is in the trust. So ultimately you want final ownership in a trust as a superior form of ownership. So that would be the takeaway and that applies to S Corps, LLC, general partnerships, etc.
Keep in mind too, guys, on the LLC, it's the same thing with the trust. We're going to need all the LLC paperwork. And here's something that we see a lot of, because we have a lot of flippers in our business today, which is awesome. They're moving properties, they're trading stuff. It's great. So they're moving their property from one LLC to the next, right? Which is totally fine as long as you do it knowing what you're doing. But what they're not always considering is their LLC in good standing? Are there some other T's that haven't been crossed, I's dotted? Keep that in consideration, because when you go to sell and it's in an LLC, we're going to ask for the LLC paperwork, and we're going to check to see if these entities are in good standing. If they're not, then we have to take action. The owner is going to have to take action to ameliorate those problems before we can move forward. So those are just small things. The great thing is when you open title with lawyer's title, we're going to send out requirements. Hey, we need the LLC paperwork. Hey, we need a statement of information from this person, et cetera, et cetera. So we try to make it very user-friendly for the consumer and, of course, professionals like Pablo and all of the Lepe Tendwell team. But with all that said, LLCs are the same thing with the trust. We need the paperwork. We need all, the T's crossed, I's dotted. Does that make sense?
Yeah, no, it definitely does. And, I appreciate everybody who showed up today to learn this topic. Thank you very much, Jeremy, for jumping on and just, adding to this great conversation. I think that's super important and overlooked by so many people. It's crazy how it's overlooked. So I want all the Lepe Tendwell agents to reach out to their clients, because you could add massive value to them right now, because a lot of them they don't know what they got. And Pablo, thank you very much, my friend, for jumping on, man. It was really good to have this conversation that we don't have enough of, and I'm sure you would know best than anyone. People don't want to talk about them passing away or their demise, and so it's something that they never even want to touch on. So thank you very much for that. If you guys have any questions about your estate plan, you should definitely reach out to Pablo. He's very detail oriented and loves what he does. So any parting words, Pablo?
It happens to everyone. It's going to happen. It's one of the most rewarding feelings on the other side of having planned, because you have not only awareness of what's going to happen, but then you also have another cabinet member in your life. So I tell my clients, look, if you're going to engage with me, this is until death do us part, and I need for you to be in communication with me. So get it done. Find someone in it for the long haul. It's a simple process. Yeah, there's some money, but you can't calculate the benefits on the back end. So thank you, Voltaire, for being awesome.
Yeah, awesome. Well, thank you. If you want to reach out to Pablo, what's the best number for you, Pablo, for them to reach out?
Well, thank you. I'll drop it here in the message, and then if they can always find me through you. I'm on social media. I'm on LinkedIn, and I would love for people who find me through this platform. Please tell me that you're connecting to me by way of Voltaire, because that's very meaningful to me.
Okay, of course, and you'll give them that free pin that you gave me, right, when you walk into the office. Hey, so yeah, you could reach out to your favorite Lepe Tendwell agent. We'll introduce you to Pablo. If you need to find out what your title's under, then we could go ahead and set you up with Jeremy as well. We'll reach out to Jeremy. So anything that you need, just reach out to us, and then we'll take care of you. Thank you, guys. Thanks, everyone, for joining. Enjoy the rest of your day. Of course, my pleasure. We'll see each other soon. Peace out, everybody.
Thanks.
Awesome sauce.
Yes, it is, man. You need
you.
to trust. All right, you're welcome. All right, we'll see each other. Take care, guys.
Thank you, Voltaire. Appreciate it.
All right. You're welcome. See ya.